You might think that a patent is only meaningful when the patent owner is making or selling the patented product. Under United States law, however, that is not so. A patent owner can enforce its patent even if the patentee offers no products or services of its own. The requirement in U.S. patent law is that the inventor disclose the invention to the public in the form of a technically detailed patent document. In return for that disclosure, the patentee receives an exclusive right to make, use, sell, or offer for sale the patented invention. That patentee is free to do what it likes with that right, including choosing to leave the invention on the shelf. When the patent term expires, usually after a term of 20 years, the invention belongs to the public. That is the bargain U.S. patent law strikes between the inventor and the public. Some other countries have working requirements, a rule that requires the patentee to use it or lose it, to produce a commercial product embodying the patent within some time period. But U.S. patent law does not ordinarily impose working requirements. In general, this is a feature of the U.S. patent system, not a bug. There are many economically legitimate reasons why a patentee might choose not to work a patent. For example, the patented technology might at present be too expensive to employ on a commercial scale. The patentee might hold the patent in reserve in the hope that the costs of employing the new technology fall in the future. Or, the inventor might be more interested in licensing the technology than in producing physical products. The patent system can facilitate efficient licensing markets, in which people who are best at inventing focus on ideas, and people who are best at building focus on manufacturing. In recent years, however, policymakers have become concerned about companies whose only business model is to acquire and license large portfolios of patents. These entities typically neither invent nor make anything. Instead, they obtain patents from inventors, package them in bundles, and seek to license them to manufacturers and sellers. Such entities prefer to call themselves non-practicing entities, or NPEs. Those who find their practices pernicious call them patent trolls. A troll, of course, is a hideous monster that hides under a bridge, waiting for an unsuspecting traveler to devour. When the manufacturer or seller refuses the license terms, the NPEs/trolls file lawsuits that assert claims under multiple patents and seek tens of millions of dollars in damages. Critics claim that NPEs/trolls hold up innovation, particularly in industries such as computer technology, by asserting inapplicable, overbroad, and/or invalid patents relating to individual components of complex products. The NPE/trolls claim that they make it easier for individual private inventors to gain the attention of giant technology companies. There have been a number of efforts over the past several years to pass legislation in Congress that would limit the NPE/troll business model, but all such efforts have failed. The NPE/troll industry is a large political lobby in itself, but some other industries that rely heavily on patents, particularly pharmaceutical and biotechnology industries, have also been wary of changes that would limit the ability to shelve patents. Pharmaceutical companies routinely obtain patents that are never worked because their business model requires them to screen tens of thousands of candidates in order to find a medically and commercially viable product. This screening process takes time, and so many compounds that must be patented early in the process never are commercialized. Nevertheless, the Obama administration believes the NPE/troll problem is important to the competitiveness of the U.S. computer technology sector. In 2013, the Obama administration issued a set of executive actions that require the U.S. Patent Office and the U.S. International Trade Commission to tighten some perceived loopholes that NPEs/trolls exploit. These actions include limiting the use of patent-holding shell companies, making it harder to claim software inventions, educating the public concerning responses to NPEs/trolls, and reviewing the circumstances under which NPEs/trolls can obtain orders to exclude the importation of products allegedly embodying technologies covered under their patent portfolios. These executive actions raise fascinating legal and policy questions that cut to the heart of U.S. innovation policy. In our computer, internet, and information age, does the policy of not imposing working requirements, a policy that is over 200 years old, still make sense? Do NPE/trolls ever play a useful economic function on behalf of small inventors, or are their actions only a drain on the economy? If Congress has been unable to enact legislation relating to NPE/trolls, should the President step in and issue executive orders? What is the proper role of the President, the Patent Office, Congress, and the courts in relation to technology and innovation policy? These are the sorts of questions industry leaders, policymakers, and scholars are still trying to answer.